Hi guys! Welcome to another episode of Attorney Javier Law Lectures. Today we'll be discussing the basic principles of the Cooperative Code, including the definition, attributes, privileges, and kinds of cooperatives. So if you like my videos and you want to see more, please hit the subscribe button. A like on this or any of my other videos would also be greatly appreciated. Please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Now let's begin. So our topic for today is the Cooperative Code, and the governing law is Republic Act No. 9520, which amended Republic Act No. 6938. And as with all things in the study of law, we should begin with the definition. Article 3 of the law defines a cooperative as an autonomous and duly registered association of persons with a common bond of interest who have voluntarily joined together to achieve their social, economic, and cultural needs and aspirations. How? By making equitable contributions to the capital, patronizing their products and services, and accepting a fair share of the risks and benefits of the undertaking in accordance with universally accepted cooperative principles. So now we know what a cooperative is. But what is a cooperative for? Article 6 of the law provides for a long list of purposes, and I won't enumerate those stated purposes anymore. You can just read them on your own. But some of the purposes of cooperatives include to generate funds, extend credit, provide goods and services, to develop the skills of its members, to encourage savings mobilization, and to ensure against losses, among other purposes, of course. Now, according to the definition, a cooperative is autonomous, meaning that it has the freedom to act independently, which is necessary in order for it to attain the primary objective of every cooperative, which under Article 7 of the Code is to help improve the quality of life of its members. Now, to attain this primary objective, the same Article 7 provides for a long list of objectives and goals of cooperatives, which once more you can just read on your own. But one goal and objective of a cooperative is to provide goods and services to its members so that they can increase their income, savings, investments, productivity, and purchasing power, and to promote an equitable distribution of net surplus amongst themselves. Now, this autonomy is one of the effects of the fact that a cooperative is a juridical person, meaning the law will treat a cooperative as having a personality separate and distinct from the members, directors, and officers which compose it. Due to this separate personality, the properties, rights, and obligations of the cooperative are its own, and they do not belong to the members. Conversely, the properties, rights, and obligations of the members do not belong to the cooperative. Okay, there is a separate personality. Okay, so in this way, it is similar to partnerships and corporations. This separate juridical personality and resulting autonomy enjoyed by cooperatives is only acquired from the moment that the cooperative is duly registered with the Cooperative Development Authority, or the CDA. Hence, the definition of a cooperative as an autonomous and duly registered association of persons. And we'll talk about registration and organization in a separate episode. Now, another similarity of cooperatives with partnerships and corporations is found under Article 12 of the Code, which provides for the limited liability principle, which simply means that it is the cooperative itself that will be and should be liable for debts and liabilities that it contracts in its own name. Okay? This is complemented by Article 29, which provides that the members can only be held liable for the debts of the cooperative only up to the extent of their respective contribution to the share capital of the cooperative. So beyond their contribution, the member cannot be held liable for cooperative debts. Again, the member only answers for cooperative debts up to the extent of his personal contribution, okay, to the share capital. Now, another similarity is that cooperatives also have the attribute of perpetual succession, meaning that cooperatives have the capacity for continuous existence even in case of the death of any member, director, or officer, which death will not have any effect on the cooperative entity itself. The cooperative entity will continue to exist and hold its properties, rights, and obligations until it is dissolved or its existence is otherwise terminated. In this regard, take note that unlike corporations which now have a perpetual existence under the revised corporation code, unless the incorporators specifically apply for a shorter term, here, cooperatives only exist for a term of 50 years, extendable for periods of 50 years. Now, you may ask, since cooperatives are so similar to partnerships and corporations, why would anyone still want to form a cooperative when they can just instead form a partnership or a corporation? Well, one major reason is that in order to encourage Filipinos to form cooperatives, the law grants cooperatives several privileges and preferential rights which are not available to partnerships and corporations. Now, the law lists a lot of preferential rights which are enumerated in Article 60 to 62 of the Code. So if you want more details, you can read the law. But here are some of the more significant privileges. First, tax exemption. A duly registered cooperative which does not transact business with non-members or the general public, meaning it only transacts business with its members, that registered cooperative will not have to pay any taxes. And this includes income tax, value-added tax or VAT, and percentage and excise tax, even donors and documentary stamp tax. Okay? However, if the cooperative transacts business with both members and non-members, meaning it transacts business also with the general public, then the tax exemption of the cooperative will now depend on whether its accumulated reserves and undivided net savings are more than or less than 10 million pesos. When we say accumulated reserves, this refers to the savings of the cooperative which are not for allocation or distribution to the members, but these are instead set aside, okay, for the protection and stability of the cooperative and will be known as the reserve fund, okay, or in short, reserves. So if the reserves of the cooperative are less than 10 million, then it shall be exempt from all national, city, provincial, municipal, or barangay taxes. But if its reserves exceed 10 million pesos, it will now have to pay income tax on the amount allocated for interest on capital and on VAT on transactions with non-members. Now, there are some exceptions to this liability for VAT, like sales by agricultural cooperatives of their products, no? But if you want to know more, you can just check out sections 108 paragraph A, 109 paragraphs L, M, and N, and section 116 of Republic Act number 10963, otherwise known as the Train Act. Okay? Those exceptions to the VAT liability are contained in those sections I just mentioned. And of course, whether the cooperative transacts business with members only or with non-members, the cooperative will still be liable to pay the appropriate taxes on any and all income that it earns from activities which are not related to the main business of the cooperative, as stated in its articles of cooperation. Okay? Now, aside from tax exemption, cooperatives enjoy certain free services, such as the following. First, free notarization by judges of the articles of cooperation and of loan documents not exceeding 500,000 pesos. Second, free registration by the Register of Deeds of loan documents not exceeding 250,000 pesos, deeds of title of property acquired by the cooperative, any document drawn in connection with any court case, or any bond of the accountable officers of the cooperative. Third, another privilege is the exemption from the payment of court and sheriff's fees for cases filed under the cooperative code, and of course others which are mentioned in section 61 of the cooperative code. Okay, so you see that cooperatives enjoy a lot of privileges, and there are actually many more, like free use of safes, no, for deposit in government offices. There's also the preferential right to supply government institutions and agencies with their agricultural products. There's also the preferential allocation of fertilizer from government agencies, and the preferential allocation or control of bottomries of vessels for their shipment of goods. Or they also enjoy the privilege of being represented in court by the Office of the Solicitor General, the OSG, free of charge, except of course in cases against the government, no? And there are many more which you can just read in section 62. I just discussed the more significant ones, and you can just read the rest in sections 61 and 62. Just remember that these privileges are granted to encourage Filipinos to form cooperatives. So now we know the advantages of cooperatives. But how do we know what kind of cooperative to form? Well, the law breaks down cooperatives into different categories and types. Cooperatives come in three categories. First, we have the primary cooperatives, whose members are natural persons, meaning the members should be actual people and not juridical persons like partnerships, corporations, or other cooperatives. Now, if those primary cooperatives form together as members, then they become the next category, which are secondary cooperatives. Okay, so secondary cooperatives are those whose members are primary cooperatives. Okay, and if those secondary cooperatives group together once more, they become the last category, which are the tertiary cooperatives. Again, tertiary cooperatives are those whose members are secondary cooperatives. Now, all those primary, secondary, tertiary cooperatives are different from federation and union of cooperative union, no? First, for federation of cooperatives, these may be formed by registered cooperatives who engage in the same business. These federations may be formed for carrying out a variety of purposes, such as to coordinate and facilitate the activities of its member cooperatives, to carry on any cooperative enterprise which complements or supplements but does not conflict nor compete with the business or economic activities of its member cooperatives, and other purposes as stated in the law. Okay, but those two are the most significant purposes. A federation of cooperatives will be distinguished from a cooperative union, which is or are made up of registered cooperatives and federations. Okay, again, cooperative unions are made up of registered cooperatives and federations who group themselves as members to represent the interest and welfare of all types of cooperatives at the provincial, city, regional, and national levels. Now, these cooperative unions, they represent their members. They promote the knowledge of cooperative principles and practices. They also develop the cooperative movement in their respective jurisdictions, raise funds, and perform a host of other purposes. But in short, cooperative unions act mostly in a representative and advisory capacity. Okay? Now, there are many different types of cooperatives, which are actually too many to discuss in detail. In fact, the law gives at least 20 types of cooperatives and allows the CDA to create even more. To mention the most common ones, we have consumer cooperatives, which procure and distribute commodities to members and non-members. We also have producers cooperatives, which produce or process agricultural or industrial raw materials or goods into finished products, which are then sold to its members or non-members. We also have service cooperatives, which may be engaged in a variety of services, including medical, dental, hospitalization, transportation, labor, electric light and power, professional, or any other services. We also have another common one, the multi-purpose cooperative. And as the name implies, this combines two or more business activities. Okay? And there are many other cooperatives, like cooperatives for education, fishermen, etc. But while the law enumerates those cooperatives and only gives a general description, the law goes further and gives special rules for certain cooperatives, which I will now only touch upon very briefly. Okay? So we have agricultural cooperatives, which are organized by marginal farmers, majority of which are beneficiaries of agrarian reform. And this is for the purpose of developing an appropriate system of land tenure, land development, land consolidation, or land manages in areas, of course, that are covered by agrarian reform. And these cooperatives are granted a preferential right in the grant of franchise and certificate of public convenience and necessity for the operation of public utilities and services. Of course, provided that it meets the requirements and conditions for such a grant that are set by law. Okay? And these cooperatives may also be given the exclusive right to perform certain economic activities in agrarian reform and resettlement areas, which may include the supply and distribution of consumer, agricultural, aquacultural, and industrial goods, raw materials, and other services, among others. In order to be registered as an agrarian cooperative, prior written verification by the Department of Agrarian Reform that the cooperative is needed and desired by the beneficiaries, together with an economic feasibility study, must be submitted. Okay? Another one with special rules would be cooperative banks. And these are organized for the primary purpose of providing a wide range of financial, banking, and credit services to cooperatives and their members. And of course, since it's a bank, it will be under the supervision of the Bangko Sentral ng Pilipinas. Now, as a limitation, only one cooperative bank may be established in each province. However, the Bangko Sentral is allowed to determine if an additional cooperative bank may be set up, subject of course and depending on the economic conditions of the province. Cooperative banks enjoy, among others, the privilege of rediscounting notes with the BSP, the Land Bank, and other government banks, and they also enjoy exemption from the publication requirement for foreclosure of mortgages covering loans not exceeding 250,000 pesos. Okay, so they don't have to comply with the publication requirement in that case. Now, another one with special rules would be the Public Service Cooperative, which would be organized to render public services as authorized under a franchise or Certificate of Public Convenience, CPC, no? So that's how you know it's a public service corporation or cooperative. It needs a CPC, no, Certificate of Public Convenience and Necessity, which of course has to be duly issued by the appropriate government agency. Now, the services that may be rendered include power generation, transmission, distribution, ice plants, communication services like telephone, transportation, services that are really in the public interest. Okay, so here we have the water service cooperatives, which are organized to own, operate, and manage water supply systems for the provision and distribution of potable water to its members and other customers. They have a preferential right to the grant or renewal of the CPC, no? We also have under this category a transportation service cooperative, no, which is organized to render public services such as land and sea or water transportation, which however is limited to small vessels for the safe conveyance of both passengers or cargo, okay, and or cargo. Next, we also have credit cooperatives, which can also be lumped together somehow with financial service cooperatives, no? Because they both encourage savings and they can provide credit and other financial services to their members, okay? We also have electric cooperatives, which should also fall under public service, no? And however, these electric cooperatives undertake power generation, utilizing renewable energy sources, including hybrid systems, acquisition and operation of sub-transmission and or distribution and supply of electricity. There are also two more, no? We have dairy cooperatives, organized for the purpose of engaging in procurement, processing, and marketing of milk and dairy products, specifically to standardize the quality and grade of milk, to assist the members to bargain for the best prices, and to effectively represent the interest of their members, no, in legislative, regulatory, and other public relations arenas, no. And the last one that that has special rules would be the housing cooperatives, no, which are organized to assist or provide access or provide affordable housing for the benefit of its members, among other purposes, of course. They may engage in the following forms of housing, no? Socialized housing, medium-rise public and private housing, high-rise or condominium housing, student or faculty dormitory housing, and others, no? So far we have discussed what a cooperative is, its nature, its attributes, as well as the different categories and types of cooperatives, and the advantages of putting up a cooperative, which lead us to the next question: how do we actually set up a cooperative? And this will be discussed in the next episode on the Cooperative Code, on the organization and administration of cooperatives. Okay, so please stay tuned for that. So I hope you may have picked up a thing or two on the basic principles of cooperatives, and I thank you for watching. Okay, I hope to see you soon. Bye.